Beautiful friends, we are waiting for the stream to connect itself all across the fruited plain of the internet. Before we can go ahead and get started, we do got to make sure the tubes are working, and sometimes they don't work, but it looks like they are alive and well right out of the gate. That's pretty nice. That's actually really good news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Donald Trump's cell phone. Apparently, Jack Smith has gone after it and gotten his hands on it, and he submitted a motion that we are going to go through today. He's alerting us to 3 different expert witnesses. You can see the filing here. It's not a long one, just about 3 pages or so, but there are 3 witnesses. We've got trial currently scheduled for March. This is the January 6th case. Now, whether that trial stays on the calendar is yet to be seen. We do know that it is being appealed, and so we'll see what happens with that out of the Supreme Court and out of the Court of Appeals. But in the meantime, we're still learning more about Jack Smith's case because they are doing everything they can to keep this thing on track. We also have this clip from Eric Holder. You may remember him as Barack Obama's former attorney general, and he's coming out explaining that Trump, if he gets power again, he could weaponize the Department of Justice and he could weaponize the infrastructure of the U.S. government against other people. But it's going to be curious to hear him explain it because it sounds like exactly what they're doing against Trump. So we'll hear from him. Then Jack Smith also submitted another motion. Remember, this is the case where Donald Trump's defense is saying, hey, you know, there's like 13 million pages of discoverable material, also known as evidence in the case, and we would like some time to review it. Do you think we could do that, Mr. Government? Jack Smith is saying, nah, objection. We don't want you to be able to review the things that you want to review. Trump has been asking the government to be compelled to give them certain things, and so Jack Smith is objecting to that in a 45-pager, which we'll take a look at. We also saw at the close of yesterday's show that the Supreme Court accepted Jack Smith's case, say it's an order in a pending case, and they said, so on, we'll get there, but they are accepting it. We're going to see what Donald Trump's response is, and when that lands. But we did have some reaction from his campaign. A statement from a spokesman came out, talked about deranged Jack Smith. And you notice how this is being titled now because he's now allowed to say that again. He's now allowed to say deranged Jack Smith. And so he's going to be using that. So we'll read through Trump's response. We'll also see what CNN has to say about this because this guy is actually right on. I think he's noticing the same thing that we talked about yesterday, which was that if the Supreme Court comes through and finds that Trump is immune, that's it for Jack Smith. And really, that's probably it for the other cases because the Big Fanny case is derivative of the January 6th case, which is the federal case. So we'll go through that clip and then we'll round out this segment, with this guy, Marc Elias. You may know him as the Democrat super lawyer. He's very concerned that other people might be voting for other candidates named not Joe Biden. And he's hitting the panic button saying, if you even think about voting for somebody not named Joe, you might as well be voting for Donald Trump. And so he's lecturing this person's viewers. Jen Psaki is lecturing her viewers, and everybody's just really telling everybody on their side, like, get in line or else. And so we'll see what Marc Elias has to say as we get into it. Then we're going to go into our second segment. Now, I was very excited. That's the wrong word to use. I was very happy with myself. That's the wrong thing to say for a Hunter Biden segment. But let me say, I was very pleased with the title of the segment, okay, that I was able to concoct here today. Hunter exposes his plea. Huh? What do you think about that? That's not bad, huh? All right, so what do you think? So he exposes his plea for all of us to see, and we're going to go through it. It's his rigged immunity deal has been revealed, and, you know, he likes to expose himself, and this time he's exposing his plea. Get it? All right. So he is submitting a motion to dismiss based on the previously covered diversion deal that we've already talked about. We've been waiting for this one, and here it is. We're going to go through it, and we're also going to go through Hunter Biden's lawyer's declaration, right? And this plea deal was rigged from the beginning. Now, we could see it, but we couldn't see behind the scenes. We couldn't see what Hunter's lawyers were seeing or what Hunter's defense attorneys were seeing. But now we have a declaration from his lawyer. So his lawyer's going to explain, yeah, this plea was totally rigged. We were supposed to have total immunity for everything. And he put it in a record, in a court declaration that we'll go through and review. And then we've got a clip from Hunter's lawyer himself, Abbe Lowell, who's saying this is just political. They're just going after a Biden, blah, blah, blah. So we'll see what he has to say about it. And you look at him, man, just look at his eyes. You know, he's perfect attorney for this case. And anyways, he's going to be rounding this clip out for us. And we'll go through all of that in detail. And then we'll close it out with this segment. Apparently NARA, the National Archives, you may know them from the January 6th prosecution, where they were really responsible for not only that prosecution and the missing records in that case, but also the classified documents case, right? They were the people who are the custodians, the head librarians for the whole country. And so they apparently are going to be disclosing records over to the Oversight Committee, James Comer and the Congress people over there, as the House inches forward in towards an impeachment inquiry. They all say it differently. So we'll go through all of that. As you can see, my friends, we've got 3 segments jam-packed today. This morning on our members only stream, we had a fun conversation about Harvard University and the plagiarism that happens over there. Absolutely amazing. And then Harvard is standing by that woman, Miss Gay, and for whatever reason, and we had the compare and contrast of her old dissertation and some of the documents that she lifted them from. So it was a wild segment. So that'll be out later. And we also talked about censorship. And Schellenberger released a flowchart that was detailing how the government censors all this material. And we covered that in detail on the members only stream. And so certainly check that out. If you want to become a member, you can do that by joining us at watchingthewatchers.locals.com. And we got some cool stuff to share. Speaking about our community and our membership, we are excited that today we are excited to launch the new merch store officially. We've been sort of sharing this over for our membos, but today on the store, all the tubes are connected, my friends. And so if you're interested in getting anything before the Christmas holiday or any of the holidays coming up, then the store is now available. And you can go, you can get a deprivation of rights t-shirt, 18 U.S. code, section 242 right there. You can get a Watcher hat in 2 different permutations. And you can get the sandals now, the flip-flopping Hillary Clinton sandals or the flip-flopping Joe Biden sandals at robertgovea.com/shop. If you go to robertgovea.com, you can just click that shop button up there, order stuff, so you can make sure you get it before Christmas. The sandals are great. They turned out to be great quality. Here's what they look like. Here's the Hillary Clinton sandal, and you'll notice that if you look in there, you'll find some errant Bill Clintons floating around. Here's the other sandal. They're nice quality. They look good, and nothing feels as good is having your feet supported by our leaders, all right? So if you want to get the Hillary Clinton sandals or the Joe Biden sandals, they're over there. The hats are stitched in America, my friends. They look great. My daily driver is this one. And so check them out, robertgovea.com/shop. It's a great way to get something cool. It's a great way to support our work that we do here. And then we're cooking up some cool stuff. I have a shirt that I'm excited to release very soon. That's going to be a lot of fun. Might end up getting us in the gulags. And so go check that out, robertgovea.com/shop, robertgovea.com/shop if you want to check any of these things out. And the Biden one, you can see this one has Hunter tucked away in some of these things. Like, see him right tucked away up there, little Hunty poking around here. Trust me, man, these are perfect for taking the trash out. These are perfect for picking up the doo-doo of the doggies. And it's just great. It's everything you need, and your friends and family will love them. Also, if you want to learn more about the Watcher symbol, you can read about what this symbol means on the shop. I wrote this entire articulation of what it means if you want to know what the Watcher means. So check that out at the shop, robertgovea.com/shop. And thanks for supporting us over there. And if you get anything, take some pictures and send them our way so we can share those with everybody else. All right. So watchingthewatchers.locals.com is where we're going to go for our after party today. And so come and check us out. If you want to be a membo, if you want to catch some extra only, members only content, that is the place to get it. All right. And so without any further ado, my friends, let's get right to it because we've got some business to attend to. Jack Smith going after Donald Trump using his cell phone now. In addition to raiding his residence and Melania's sock drawer, we've now got access to the president's cell phone, and they want to use it to pinpoint where he was geolocated in the White House on January 6th. And they also want to look at the web pages that he may or may not have visited and the things he may or may not have sent to other people. We know that Jack Smith got the Twitter warrant access, so we already got anybody who liked Donald Trump's posts. All of his DMs were all captured in that, and now they got the cell phone too. So we're going to go through two filings. One is Jack Smith's cell phone expert witness disclosure. He's saying, Your Honor, Judge Chutkan, when we get to trial, here's what we intend to do. We've got these three people. We're going to share who they are. We've also got an objection from Jack Smith against Donald Trump saying, you're not entitled to discovery. Why do you need evidence? You should just plead guilty and take the sentence. And then we're going to go through some reaction to what SCOTUS has done, because they did accept Jack Smith's panicky request to really expedite this entire proceeding so they can get this done before the election starts in March, when the primary Super Tuesday date is. We also got reaction from Marc Elias, the Democrat super lawyer, and others, but let's just dive right into it. So Jack Smith wants Trump's cell phone, may already have it, and may have some good stuff in there to use. We don't know. Or maybe there's nothing in there at all. But this is what he is filing for us. It's a 3-pager, not long. It tells us that this is the government's summary of anticipated expert testimony, and the trial is on hiatus right now. The January 6th trial is not scheduled for March. I mean, it is technically scheduled for March, but the likelihood that it goes on March, I would say, is very slim, because they know it's currently on pause. So unless the Supreme Court really gets moving on this thing and we have oral arguments, or maybe they issue something that they do without the oral argument, who knows what they do. But it's likely that that date is going to be movable now because a bunch of stuff has happened. And Jack Smith expedited this, right? He is the person who leapfrogged the Court of Appeals and took this right up to the Supreme Court. So it's on hiatus, but we know that they're asking Judge Chutkan to keep the train on the tracks in case the court does come back quickly. They're ready to go. Boom. Because that could happen too, right? And they're planning for all contingencies. So they say, here's the deal, Judge Chutkan. January 6th case out of the District of Columbia. The court now submits the court's brief description of each expert witness's area of expertise and expected testimony. Why? Because the judge ordered them to do it. Saying, Your Honor, as explained below, the government may call up to 3 expert witnesses to testify in this case. And it's just a may. They're not required to do it, but they're just noticing them. They say the first expert, pretty skilled guy or gal, says that this person has knowledge, skill, experience, training, and education beyond the ordinary layperson regarding the interpretation and visual representation of geographic location data. So they scrape all the details off the phone and they can do something with it, make it look pretty. The government expects that expert 1 will testify about his or her use of ArcGIS, Geographic Information Systems, software that's going to create a map of the Google location history data produced in response to a search warrant. So you know how on Google you can go your history, it says you were here for 10 minutes, you were here 2 weeks ago, you were here 3 months ago, whatever. They can reassemble that. Now specifically, expert 1, who's already done this, plotted the location history data for Google accounts and devices associated with individuals who moved on January 6th from an area at or near the ellipse to an area encompassing the United States Capitol building. So from the ellipse to the Capitol. Now, who were these people? Who were the individuals? They're not referencing the defendant. So we'll see. Now, his or her testimony, meaning the expert witness, will describe and explain the resulting geographical representations of that data. And when they put all this on the charts, it's going to aid the jury in understanding the movement of the individuals towards the Capitol area during and after Trump's speech at the ellipse. So it may not even be for Trump, right? Just individuals in general. So it's like they're going to say Trump said a thing and Trump's statements caused all of these things to move, right? What I'm imagining is this fancy geographic rendering, right? I can just envision it now. They have Trump's speech on this frame of the video, and Trump is speaking right here. He looks great, right? This is him. Fantastic hair blowing in the wind. And he's doing a great job saving America, speaking about rigged elections. And then simultaneously, they have this geographic recreation. And you see a big group of people kind of all scattered around here, right, at the outset. And they have the time clock at the bottom, and they play the time clock, and they just like Liz Cheney had for us. And it almost looks like a Chick-fil-A commercial or something right now. But this is what you have here. And then this is the time clock. The time clock's running, and Trump says the thing, the bad phrase, right? Fight, right? And then what happens is these people start to move, right? Like a football game, right? They all move this direction. And he says, okay, so what that's going to do is show that Trump said the thing and all the people move simultaneously, something like that. And he's going to come in and it's going to show Trump's words did it. They weren't moving until he said the thing. And then people started texting each other, and the texts corroborate this. And there's, attack the Capitol, blah, blah, blah. So that's going to be expert number one. Now, expert number two. He's going to have knowledge and skills and training, and he's also going to have expert education beyond the ordinary layperson, which is the standard. You can't just bring in some bro to come testify. He's going to talk to the ordinary layperson about the analysis of the location data and location history data, including Google location data, to also determine the approximate location at which a device with Google location history activated was used at particular time or ranges of time. So what certain devices were used and when. The government expects that expert 2 will also testify about the process of determining the device location, the collection and use of location history data by Google, how it works, location history data produced in response to a search warrant, right? They got all of X's stuff. And they also want the graphical representation prepared by expert 1. So they're also this guy's going to comment on this. Well, how'd they get all that? And how does that work? His or her testimony will aid the jury in understanding the movement of individuals towards the Capitol area during and after Trump's speech. And then, right, those two are kind of general witnesses. But then we get to the one that really matters. Expert number 3. Now, expert number 3, this person has knowledge, skill, experience, and training and education beyond the ordinary layperson regarding the analysis of cellular phone data, including the use of Twitter and other applications on cell phones. So they gobble the whole thing. The government expects that expert 3 will testify that he or she, number 1, extracted and processed the data from the White House cell phones used by Trump. So the device that was used by the defendant, Trump, and one individual who we don't know who that is, individual 1. So they're going to go pull it all out. They extracted and processed the data from the White House cell phone that they assigned to Trump. Now, I don't know what personal cell phone, White House assigned cell phone, whatever. But he turned it back in. Turn in your keys and your badge and your gun, Trump. Insurrectionist. Here's your cell phone. And he leaves. And so they pull it all off. So they also say that how they got it, okay, how they jacked everything off of it, but then also reviewed and analyzed the data on Trump's phone, what they did with it, including analyzing images found on the phones and websites visited. So is Trump going to Wikipedia and typing how to seize power in a country? What is the definition of insurrection? All right, something like that. Is that what they're planning on? And 3, determine the usage of these phones throughout the post-election period, including on or around January 6th. Specifically, and 4, I specifically identified periods of time during which the phone was unlocked. And the Twitter application was open on January 6th. So they pulled the logs. So they pulled the logs out so they can just see Trump is just scrolling on Twitter, right? He's like, he's just scrolling. Okay, Capitol buildings being insurrected. And this guy's just like, scrolling around, right? They can see. How long was he on there? What else was he looking at? Was he tweeting at the time? Well, he was. He definitely tweeted a video message. And so they're trying to analyze this, right? And see what's happening there. Now, also images. Was he taking pictures? What websites did he go to? Insurrection.com? Who knows? Determine the usage of the phones during the post-election period. And this is serious stuff. I mean, they're going to be using this selectively, picking out whatever. And they're going to say, that text message is used for insurrection. And that is insurrection. And you search for that, which is insurrection. And blah, blah, blah. Okay, so your cell phones are obviously, not sacred spaces when they're in the possession of law enforcement, but neither is the president's. And they just gobbled the whole thing up. They got all of his X account, all of his Twitter account has been, gobbled up. If you liked anything that he posted as well, they gobbled it up. Yeah, and then when he said go home in peace, they actually closed the Twitter account. So he was on it, and then they X'd it out. Very strange. So the person who wrote this one was Thomas Wyndham, Jack Smith special counsel, going after Trump's cell phone now, in addition to everything else, including Melania's sock drawer. But that was the original filing. Now, you might be asking yourself, how is this even feasible? How can they, get away with garbage like this? Well, it's because it's orchestrated in part of a political operation. And Eric Holder, who is Obama's former attorney general, might still be running things at the AG. Who really knows, since Obama's probably running most of the White House as well. He explains exactly how this works. So if you're wondering, wait a minute, how did they just go and get access to his cell phone and his sock drawer with Melania there and so on and so forth? How can this happen when we have things?
Sure.
We have things in this country like due process of law, equal protection under the law. You're supposed to have judges that sign off on warrants. You're supposed to have agents that swear an oath to uphold the law and blah, 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 all this nonsense, right? We all just remember from a bygone era. But this is Holder explaining exactly how it works. Now, he's going to talk about it in the context of Trump, but just pay close attention to it. This is exactly, literally, what they're doing. This is the playbook.
Sure. If the president told a compliant attorney general, I don't like what this congressman said about me or did about
Biden
me,
to Garland.
did to me over the course of the last 2-3 years, whatever, open an investigation on that person.
Just like
that attorney general could tell a compliant United States attorney to do just that.
Yeah.
Talk to a compliant
Molly,
FBI director who could be replaced by the president to open an investigation and then to just look through that person's life and look for anything that you possibly can find.
Documents.
And who's to say what you find in any person's life that might run afoul of the law, and even beyond that, the mere fact of an investigation of a person who is a public figure can be reputation ruining, can be politically damaging, not even if you find anything, just the fact that the investigation itself exists. And if you've got the full weight of the Justice Department, the full weight of the presidency, the full weight of the FBI focusing on somebody like that, that can be extremely damaging to not only that person individually, but to our democracy writ large.
Yeah, you're right about that, Eric Holder. You nailed it, man. Absolutely home run. Well done. So why are the Democrats doing that? Why is your party doing that? Maybe he could answer that question. CNN is, of course, not going to ask. They're going to base this on Hunter Biden. Poor Hunter is being prosecuted, right? Meanwhile, that's their entire strategy. So that's how they do it. Now, when they are prosecuting you in this new regime, you also don't get access to discovery. So if you think that you've been charged with a crime, well, at least you can be advised about what the evidence shows against you, right? I mean, this is still America. Wrong. Jack Smith objects. Trump wants access to material. Sorry. Government is in opposition, objecting to Donald Trump's discovery motions. How dare he get access to material he needs? They write this in a 45-pager out of Judge Chutkan's courtroom. They say, Judge Chutkan, Donald Trump demands an unprecedented expansion of the government's discovery obligations that would provide Trump with special treatment and result in a delay of this case. They say Trump asks this court to find that a wide array of entities, both inside and outside the executive branch, are part of our team. Right? Jack Smith just wants to say, no, it's like me and Molly and Jay. There's like nobody else working on this case. It's just us three. We just have sleepover parties and tickle fights with Judge Areola. But it's just us. It's a small team. This is not true, obviously, right? We had the CIA was involved in the cover-up with Michael Morrell saying, I just don't like Trump, and orchestrating with Anthony Blinken to psyop all of America. Okay, so we want to know who else was involved in this election rigging that goes to Trump's main thrust of this claim, which is he is allowed to speak about a rigged election as the executive of the country. So he wants to expand this. What does the FBI know? What does the CIA know? What does the NSA know? What does the DOD know? What does everybody else who is involved in this know? But they just want to limit it down. They want a small hula hoop versus a big hula hoop. So they continue. Jack Smith's team says, and Trump, he further demands that the government search the files of all of those separate entities, like the FBI and CIA, for broad categories of information that are not even relevant to our case. Says Trump's view of discovery is untethered to any statute or rule and lacks anything that justifies it here. And the information he seeks is not even in the government's possession, right? And you listen to this term, okay? The government's very sneaky here. The government, in my position, is anybody who's collecting a check from the federal government or even in the chain of that, right? If you're doing work and collecting from a contractor that's being paid by the government, all right, you are an agent of the government. So the government is monstrous. It's not like Jack Smith, Jay Bratt, and Molly, right? It's bigger than that. But no, it's not in our possession. We don't know where it is. There's a lot of buildings in the government, but it's not in our office. So we don't have it. And she says in many cases, what they ask for, it does not even appear to exist because maybe it was deleted with Liz Cheney's records. In any event, it's not even discoverable under the rules, under Brady. It's not discoverable under the criminal rules of procedure, and therefore Trump's motion should be denied. Now they say, Your Honor, Judge Chutkan, to camouflage that his demands are unsupported by the facts or the law, Trump confusingly separates his discovery claim into two separate motions. One, to determine in the abstract the scope of the prosecution team, how big is the hula hoop, without any reference to documents, and then making a separate filing as well. And the government sets forth below why he fails on both fronts. They say, first of all, the scope of the prosecution's team has already been established, okay? We have rules like Brady that tell us exactly how all of this works. And they say the closely aligned prosecution is here. It's limited to entities that have significantly cooperated with and provided substantial information to the government's investigation. So you don't get everything that you want. It's got to be closely connected. Now here, only where the relationship exists and the government has access to the documents will the courts consider whether the government should obtain the documents. Right? And the courts basically have recognized that the government is a big, disgusting monstrosity, my words, not theirs, and that it's really hard for the government to go navigate through the twisted web of bureaucracy to obtain documents, right? So they just, well, it's like a lot of work for them to do that. And they don't have an obligation to go comb through every other agency just because somebody requested it. They say, as we've explained, Your Honor, the test demonstrates that Trump can't even meet the standards. And so you have to find in our favor. They say, first, Trump, his argument just creates an entirely new test of law that doesn't even matter. And then he cites to this claim, which says that executive branch agencies are very broad. And third, he also relies on factors that have nothing to do with whether the entity in question is even closely aligned with the prosecution. So his tests are all wrong. And besides, the things he's asking for, he's not even shown that he needs them yet. He's not showing that they're material to this case. And the rules say, Rule 16, that it needs to be material. Saying overbroad discovery requests, Trump asking for things that he doesn't need, is against the rules. It's cumulative information, and he's not entitled to it. Now, as Trump has done elsewhere, Trump miscasts the relevant case law, and he incorrectly asserts that materiality only requires some abstract logical relationship to the case. But here, Trump is actually stating the opposite of what the law requires, and he misquoted the Fifth Circuit, and they're dum-dums over there. And he says also that Trump is talking about potentially classified information, but he doesn't even know what's in there. And by the way, he's not even entitled to the classified material is not even discoverable in the first place. And so that is the reason, Your Honor, Chutkan, that you should reject his arguments. Said he seeks to add to the prosecution team an entirely separate investigation. Now, this is something we've been seeing out of these cases for a while that's pretty disgusting. When the Proud Boys were on trial or the Oath Keepers were on trial, they would say, well, there's a bunch of undercover FBI informants or other informants. We don't know who they are, but where did they come from? And the government would just say, well, they didn't come from the FBI, so there's nothing that we need to do about it. We learned that they're from HSI, Homeland Security Investigations, right? And there's apparently dozens, if not hundreds. I don't know the final number. It'd be nice if they told us, honestly. But a lot of people, 50 at least, that were identified by the Proud Boys defense attorneys in court. And they just segment them out. They say, no, you're outside of the hula hoop, right? You're outside of the scope. We don't need those people to actually incriminate you, and they're not part of our case. So they say Trump is saying, well, I don't care if they're not a part of our case. They might have information that is Brady that exonerates me, and I need to know what they were up to so I can prepare my defense. Well, they say, sorry. Trump wants the government to add a separate investigation, distinct components of the DOJ, which is called the Department of Homeland Security. They're like, that's an entirely different building, man. And there's 250,000 employees over there. Oh my gosh, 250,000 people at DHS. Can you imagine? Now, they also want to add the nation's entire military apparatus, which is 3 million strong, and the 18 federal agencies that comprise the intelligence community, and a now defunct committee of a separate branch of government, which is the illegally constituted January 6th committee, right? Which was that one. So Trump says, yeah, I want it all, man. Milley was involved. Milley was with the DOD. We know the CIA was involved with the laptop cover-up letter. And we're talking about election rigging, right? So yeah, it does extend to all of these other things. And Trump wants to know. They say Trump has already received the discovery that we've got in possession of the government. And so their definition of the government is like their little closet of, prosecutors and agencies that they say are closely aligned with the prosecution, right? But they got a bunch of records, as we know, from the January 6th committee as well. So saying the court should reject Trump's boundless arguments based on factual misstatements as well. Now, they say that Trump says that the prosecution team should encompass a lot of people. The entire special counsel's office, including staff and everybody in the Southern District of Florida. But the government has taken a broad approach to discovery. They're saying, we've given you a ton of information. Yeah, 13 million pages. The government also included in this case items overlapping with Florida. And this practice will continue. We're continuing to dump all sorts of material in there. In some, Trump demands relief for a problem that does not exist. So she's saying, look, we've given you a ton of material. We've given you 13, 14, 15 million pages of documents. Trump says, well, we don't care about those 15 million pages. We want that. We want those 5,000. That's it. She says, you don't need those 5,000, though, because you got 13 million, right? And that's the argument she's making. Now, they say Trump, next, he tries to define the prosecution team to also include everybody in the D.C. Washington office. And remember what happened, right? Like these people were Molly was already working adverse and opposed to Trump well before Jack Smith was appointed. Same with Thomas Wyndham. So when Jack Smith got appointed, he just gobbled up these people. They just all got promoted to the special counsel team. So Trump is saying, great, I want to know what they were doing when they were in D.C. during their investigation. And they're saying this is just misplaced. The special counsel, they say, is completely separate from these other entities. And they don't answer to the U.S. attorney for D.C. And they don't answer to us. And so we have done our due diligence. And Trump knows that, saying his principal complaint appears to be from the Capitol breach cases, which is what the D.C. office is attending to. But they say the government has made Trump offers and he's not responding to their requests. And so his complaint is undercut. He's not even searching the database like he wants to. Who wrote this? Is this Molly who wrote this? Oh, gosh. No, it's Thomas. Okay, Thomas wrote it. All right. Sounds a little bit whiny like Molly. All right. I'm not sure. But so, they're both very whiny. It's hard to tell. So rather than pursue and review the discovery available to him, Trump attempts to use as a cudgel the government's unaccepted offers of access to review these things. And so Trump is not even using what we're offering him, so therefore he should not get more. Now, they're saying that he also wants access to the Washington field office. He also wants access to the DOJ headquarters. They're saying he did get some stuff from the DOJ, but he's making broad assertions about this, and it's not specific enough for us to give him information from the DOJ. Trump also wants stuff from Homeland Security, obviously. They say, he moves over here, focusing the scope of the prosecution arguments on the Secret Service and CISA, two agencies that we would like to know more about. But here again, they say Trump fails. He doesn't need discovery from them. Why does he need evidence to know what they know? Secret Service is only there on the Well, there were text messages that day that apparently have gone missing. So where'd those go? And CISA was apparently the ones responsible for a robust cybersecurity of a rigged election. So shouldn't they have information that Trump should get as part of the discovery? But our own government, the people who say, no, due process of law, no one's above the law. They want to prosecute someone without any evidence. Without giving them, they have all of the evidence, to be crystal clear about this. Like, it's the government, the DOJ has it, or can get it, but Trump can't review it. And they don't have any obligation, their argument is, to go get it. Now, here they say Trump fails because he's already been provided with the material related to those agencies that is in our possession. Okay, so we've given him everything we got, which is how they work. They just don't go get things, so they don't have to give anything. And then say, well, we don't have any obligation to get it. Now, they say first about the Secret Service, much, if not all, of the discoverable material from it was obtained through compulsory process, demonstrating the agency is not part of the prosecution team. Okay, so Jack Smith had to go order it and demand it from the Secret Service. Now, in addition, that material, which they say is only marginally relevant, which no one cares about their opinion on that. Like, the defense wants it. Now, they're making the argument to the judge, but the defense says it's very relevant. So thanks for your opinion. And yet it constitutes a sizable portion of the discovery. They say it's already been given it to them, but not all of it, much, if not all, right? So you see how sneaky these people are? It's already been given to him, not all of it. Though the defendant points to the fact that the government obtained during the investigation. So they're saying, okay, here's the things that we want. And the defense always wants the things that they're not going to give to them, obviously. Trump points to the fact that the government obtained during the investigation several official phones from Secret Service employees. Now, he says he fails to inform the court that the phones did not contain any recoverable information. Isn't that nice? Phones were deleted. And that though he informed that the government intended to return the phones to the Secret Service, Trump failed to interpose an objection. So the data is deleted. Weird. Now, finally, additional Secret Service information contained in the discovery database that Trump's not looking up. And so against this backdrop, Trump fails to identify a single item or category of items from Secret Service or DHS more broadly that he does not already have, that he says he needs, or that will significantly alter the quantum of proof in his favor. This is definitely a Thomas motion based on that one. Quantum of proof. All right. Thanks, Thomas. Now, the defendant's arguments over material from CISA are also unavailing, saying Trump suggests that CISA assisted in the investigations and he should be able to review the discovery. But even under that, they say the facts don't show that he's entitled to this. As part of our investigation, the government interviewed a single CISA employee, and that's all. And we've already given them everything. And now they say he wants access to the DNI, the CIA, and the DOD as well. But he's not offering facts. Instead, it's just baseless conjecture. Now, he asserts, Trump, that the DOD assisted in the investigation, but without more specificity, they say we can't find anything. So Trump says, I need some things. And they say, well, unless you're specific about it, I can't give it to you. And you say, well, I don't know what you have. Well, we can't tell you what we have, but I want to see it so I can prepare my defense. Well, I'm happy to give it to you, but you have to tell me what you need. I know, but you have everything, and I just need to see what you have so I can make my requests. Well, I'm happy to oblige, but where would you like me to start? Now, absent such specificity, for what Trump requests is for the government to search the holdings of a military apparatus that employs 3 million people. Oh, you want us to search through everybody's email inboxes, huh? Now, in its investigation, the government has interviewed one then current and now former DOD official, which is a small number of the former DOD officials, and we've already given the defense to everything else that they need. And they've also, everything related to the DOD that we got from the select committee, we've also given over. Now, they say they also want information from the CIA, which would be nice. Now, they want this as well. The defendant tries to import that the CIA was part of the prosecution team because the CIA was working with the special counsel. But unlike this, CIA is a separate investigation, okay? So they're doing separate business. It's CIA business. You're not entitled to know, or we'll have to kill you. So they say here, right, also, finally, from the Congressional Select Committee, they say, finally, Trump speculates about coordination and extensive access to argue that the prosecution team includes Liz Cheney and everybody else. But there's no authority for this. And it's overbroad. And it's a separate branch of government. And in any event, we've already produced things that we've gotten from the Select Committee. And there's no reason why we should be ordered to go get more. And say, therefore, courts here, Judge Chutkan, you should deny Donald Trump's discovery demands because he fails in its entirety. And you can see a lot more law in motion here as we get through the bottom of this. A lot of this is barred. In conclusion, he's asking you to make us do a bunch of stuff that we're not entitled or required to do. He's failed to establish the materiality for any of them. And so why should he get any evidence against him? I mean, it's just America. We gave him what he needs, right? It's like 100,000 million pages of just, New York Times trash articles that nobody cares about. They're like, no, it's Discovery. You'll like it. So it's Thomas Wyndham signing it, signed off on by Molly. I'm sure she proofread this thing. It sounds like a team effort. But that was submitted opposing Trump's attempts to get discovery. Now, Jack Smith is also taking this to the Supreme Court and trying to get them to accelerate this case because it's basically on hold now until we can get this immunity issue resolved. But the Supreme Court accepted the case, kind of. We'll see what they do next, but this was an order that came out Monday, December 11th. Jack Smith saying, do we have the right to even prosecute this guy? And can you decide on this quickly, please? Court came out, says Jack Smith's motion to expedite consideration of the petition for a writ of certiorari before judgment is granted. And respondent Trump is directed to file a response on the petition before 4 p.m. on Wednesday, December 20th. And so you see, that is what has been filed. Now, Donald Trump has responded to this. And the government is getting a little bit nervous because if this goes against them, Jack Smith's case could be over. Here is what Liz Harrington with the Trump team posted. She said this, that crooked Joe Biden's henchmen and more. Trump explains. December 11th, 2023, a statement from a Trump spokesman on deranged Jack Smith's filing with SCOTUS, saying, crooked Joe Biden's henchman, deranged Jack Smith. That portion of the gag order was overruled. Is so obsessed with interfering with the 2024 presidential election with the goal of preventing President Trump from retaking the Oval Office, as the president is poised to do, that Smith is willing to try for a Hail Mary by racing to the Supreme Court and attempting to bypass the appellate process. Deranged may need to be reminded that the Supreme Court has not been kind to him, including by handing down a rare unanimous rebuke when the court overturned him 8-0 in the McDonald case. As President Trump has said over and over again, this prosecution is completely politically motivated. There is absolutely no reason to rush this sham to trial except to injure President Trump and tens of millions of supporters. President Trump will continue to fight for justice and oppose these authoritarian tactics. Trump spokesman. Now that's the statement on December 11th, and I agree with that, and I think that's the right play. No reason to rush this. Take your sweet time. Just work its way up, and we'll see what the Supreme Court does. But if the Supreme Court does find in Trump's favor and just resolve this thing, relatively quickly, no, the president's immune, obviously, without much fanfare, not going to be good for him. And they're getting a little nervous about this. So some people in the media are trying to cope their way through this bad deal. We were here yesterday saying Jack Smith is panicked, man. They just freaked out. And that's why they filed 3 simultaneous motions. One with Chutkan saying, no, you can keep the trial on the track. One with the Court of Appeals saying, please accelerate this and find in our favor. And one with SCOTUS, because they have to have this March date go. Because if they can't have it go in March, what are they going to reschedule it for 6 months in September? No, not with the election around the corner. So it might have to go into 2025, and they would absolutely hate that. And so A lot of cope out there on CNN and MSNBC. Jack Smith's very smart by having to go to the Supreme Court. He's boxing Trump in. No, my friends. They're getting boxed out here. They're running out of time, and they're hitting the panic button. And so this guy actually, to his credit, makes the same point. He's acknowledging, look, all that happens here, if the Supreme Court comes back down and finds Trump has immunity, cases are gone. So it's kind of a twofer thing, right? We were happy to get to the Supreme Court. We were just expecting it to take a little longer. Like Jack Smith fast-tracked it for us. Thanks, Jack. Here is what the outcome might be.
Paula said that she doesn't think that a ruling on this case would necessarily impact any of the other criminal cases Trump is facing. Do you agree?
So I agree with Paula 99% of the time. I slightly disagree on this one. If Donald Trump is to win here, obviously Jack Smith's federal election interference case is out the window. I also think Fonnie Willis's case is doomed. Yes, that is a state-level case, but the principles of immunity would apply whether it's a federal or state-level prosecution. Again, that's if Trump wins. I do agree with Paula. This will have no impact on the hush money case because that conduct almost entirely happened before Trump was president, and it definitely will not impact the federal Mar-a-Lago classified documents case because that conduct was entirely after Donald Trump was president. But if he wins here, I think 2 of the 4 cases are going to be out the window.
Alyssa, Mr. Trump was supposed to testify in his New York trial
today. So they switched over to New York. Nobody cares. So that is interesting, right? And that's exactly right. If immunity comes down, I think both those cases are over. And also, the Florida case, they're going to say obstruction happened after the fact, and it's really a separate issue. Yeah, so it's going to be a lot of fun. So they're a little nervous about that. And so is this lawyer, Democrat super lawyer Marc Elias. Some people might say the architect of the legal onslaught that Republicans faced in 2020 is starting to hit the panic button himself. This is what he sounded like on this guy's show. And he posted, he said, on his X, he says, hear my message loud and clear. If you vote for Jill, RFK, no labels, you're voting for Trump.
Anything other than
Matt.
And let me just tell you something. If you think voting for Jill Stein is doing anything other than electing Donald Trump, you are wrong. If you vote for Jill Stein, you're voting for Donald Trump. If you vote for Bobby Kennedy, you are voting for Donald Trump. If you vote for the no labels candidate, whoever he or she is, I don't even care. I don't even want to know. Don't spare me. Spare me it's going to be a Democrat or a Republican or Joe Manchin or this person. If you vote for the no labels candidate, you are voting for Donald Trump. And I'll tell you one more thing. If you sit at home because you're disappointed, or you sit at home because you think your vote doesn't matter, or you sit at home for whatever reason and you don't vote, you're helping elect Donald Trump. So, I'm tired of the people who are saying I'm going to have a protest or I'm going to sit out or, we're disappointed because the Supreme Court, struck down the student loan. Joe Biden fought for student loan relief.
Yikes.
Joe Biden has fought for more things than he's given credit for. But even if those were aside, if you don't participate in this election and enthusiastically drag your friends, your neighbors, your family, drag them to the polls, make sure they're registered, drag them to the polls and make sure they vote, then you are feeding into what Donald Trump wants for this country, which is a dictatorship.
Oh, a dictatorship. So you know what to do, my friends. I guess vote for a dictator, I guess, is where this is going. So if they're going to be dragging people to the polls, we're going to be dragging up people to the polls. And I think we're going to drag more people to the polls this time around there, Mark. And we have to overcome the margin of fraud that was instituted last time. And so you can see a little bit nervous out there. You add that to Jen Psaki. Jen Psaki's telling people, hey, there's like 533 journalists who are imprisoned. You say, does Trump have anything to do with that at all? No. But he talked to Putin once. Okay, thanks, Jen. Thanks, Mark. They're nervous. There's a reason for it. Their attempts are not working, and the date is just dripping through their fingers, and they were not expecting that, man. Jack Smith just hit it 3 times, and he leapfrogged the Court of Appeals, going right to SCOTUS because the clock is ticking. And my friends, we'll be here to continue to cover it. Thank you for subscribing. We're covering all the Trump trials and more. We'll look forward to seeing you here. Thanks for checking out robertgovea.com, and thanks for checking out the shop and grabbing a new hat at robertgovea.com, the new Watcher hat, and learn more about the Watcher symbol over there. And we'll look forward to seeing you right back here on the next one. All right, my friends. Now, let's turn our attention over to what's going on with the DOJ and this rigged plea deal. because this one's pretty amazing. Hunter Biden exposes his plea, and he's going to show us how rigged the plea deal was in his favor. Now, he is now being prosecuted in a parallel jurisdiction in California, and this is not that. We are in Delaware, and Hunter submitted a whole slew of filings going after the DOJ, his daddy's DOJ, saying that they have reneged on a deal. And Hunter filed a motion to dismiss. Now, in this motion, he's going to share with us a declaration from his lawyer, whose name is Christopher Clark. Clark was the guy who orchestrated this deal, who shows us how rigged it was between David Weiss. They wanted this whole thing to go away. Then when it went off keister, they walked away from this thing. And now they're saying that immunity is still extended over Hunter and the deal. Hunter's lawyer, Abbe Lowell, is saying that he is being victimized, not Trump, that the DOJ is so bad that they're also going after Biden. And so we're going to see what he had to say about it. But this is what the motion to dismiss looks like. The diversion deal. And I've been waiting for this one. I know you have too, because when we were going through the plea deal live the day of the transcript release, about as live as we could get, we watched it unfold in real time. We watched Hunter deny and reject a plea deal when he absolutely should have taken it. And we were going to say, they're going to still say that it's in effect. And here it is. This is Mr. Biden's motion to dismiss his Delaware indictment. He says, I've got immunity. I have already taken a deal in the diversion agreement that precludes me from being charged anywhere else. You see, this is filed out of the District of Delaware. It's a 29-pager. We'll hit the highlights on it. It's being filed by Abbe Lowell. And this is how it starts. They tell us that the indictment against Hunty Poo must be dismissed because it violates a diversion agreement that's already in effect between Hunty and the prosecution, the rigged deal that we watch break down in front of us. In exchange for Mr. Biden giving up his various rights, including his Fifth Amendment right to remain silent, he agreed to the statement of facts drafted by the prosecution. He placed numerous restrictions on his liberty, and the prosecution agreed to provide him with immunity. You're asking yourself, wow, why did they give him that immunity? We just saw a whole litany, 50-something plus pages of Hunter's just scratching the surface of his criminality in the California indictment. So why were they going to do this? Now, any offense concerning the purchase of his firearm and other offenses. Now, as the prosecution told the court, they said, quote, based on the terms of the agreement, we cannot bring firearm charges based on the firearm identified in the factual statement in the diversion agreement, saying, but the prosecution did that. And they later brought subsequent charges and indictment charges charging Hunter with 3 felony firearm offenses, which all relate to the firearm in the diversion agreement. And because Mr. Biden gave up valuable rights in exchange for this, such promise must be fulfilled, right? So there was a contract. Hunter got promised no charges. He held up his end of the deal, and now they're reneging, saying the prosecution filed 2 separate charges against Hunter, June 20th and another one later. Failure to pay taxes, failure to timely pay taxes as well. 2 misdemeanor tax offenses. Now, the prosecution resolved the information on the gun charge. There was a diversion agreement. And the prosecution is trying to renege on that agreement by indicting Biden again with 3 new charges. And the court granted the government's motion to dismiss the information, which was the other charge, because it was replaced with this one. Now, they tell us that after the court on August 17th dismissed the other charge, new charges are here, and now Hunty seeks to dismiss. They tell us. Your Honor, concerning the gun charge, Mr. Biden resolved the information on the gun charge the day that we read the motion, the diversion agreement. Say it's already done. The only parties to a diversion agreement are Hunter and the government. And we were watching them as they tried to do this, right? They tried to button up all of the other criminality, everything from his so-called, crackhead years was all immunized as part of the diversion deal. That was separate, and he was just pleading guilty, and the plea deal that he was pleading guilty to incorporated the diversion agreement, which was outside the scope of the court. That's how they were sneaking it through. And the judge caught him. says here, Roman numeral 1 said that the diversion agreement are the United States here, right? The parties are the United States of America and Hunter. In other words, Judge, you're not involved in this, so you don't get to say anything. That's why they constructed it this way specifically. Every party to that agreement was signed on July 26, and the court's approval was not needed for it to become effective. Now, they're going to say that negotiating this resolution was made difficult because the prosecution could not make up its mind, blaming the DOJ. Wow. About what it wanted, and they repeatedly moved the goalposts whenever a resolution was in reach. Christopher Clark, we're going to read his declaration, Mr. Biden's primary lawyer who negotiated the agreement, described the negotiations in length in his declaration, which we'll read. Initially, the prosecution required only that the resolution be public, one, and involve an agreed-upon statement of facts after we could reach some sort of non-charge, non-prosecution agreement. Throughout all negotiation, Mr. Biden always made clear that any resolution reached must bring finality to the investigation. Now, after the prosecution informed that that was acceptable, Mr. Biden agreed in principle. The prosecution then explained that David Weiss changed his mind. Nope, sorry, you can't get a total dismissal. He then wanted a deferred prosecution agreement on the gun charge. So Weiss is getting some public pressure from somebody. Later, the prosecution then said, okay, how about no deferred prosecution, but how about a diversion? They're different, technically, but ultimately the same. Both charges get dismissed. It's just the mechanics of how you get there. Charges would be filed on the gun charge and 2 misdemeanor tax charges, but no plea would be required. Now, after that agreement in principle was reached, Weiss changed his mind again. And so Weiss wanted, it's going from basically nothing to a little bit harder, to a little bit harder, then to a little bit harder. And this is as the whistleblowers are coming out, right? Like the pressure is coming on. And yet again, he insisted on a guilty plea on 2 misdemeanor tax charges as well. So then Hunter and his lawyer, they continued to insist a resolution that would resolve any and all investigations of Hunter completely. And the prosecution made clear that that would be accomplished. We would have immunity for all the conduct described in a broadly worded statement of facts. And I got to tell you, I totally believe Hunter on this. 100% I think this is true. Because it's the DOJ. Like, they're corrupt as hell. And like they're weaponized against Trump, obviously, as we're watching. And they rigged this thing broad. I mean, we watched it in real time and read. If you missed that segment, man, you got to watch that one. When Hunter's plea deal broke down, because they gave him everything that you could possibly ask for. I couldn't even believe it. And it was so broad and it was so, craftily, sneakily concocted. It was incredible. The judge busted him. So I believe this. I believe that the government was giving them this. It's such a crazy deal that you have to wonder why they were even trying it, and it's like the DOJ was agreeing to this. Okay, but they did it. Now, ultimately, the prosecution drafted the diversion agreement, conferring such immunity that was signed by all parties, which would not require the court's approval, and a separate plea deal which the court would enter. As explained below, the court can and should resolve this motion based on the face of the diversion agreement. And this is true, by the way. Like, a diversion agreement is a common thing. This is not unusual. This happens all the time. In fact, I'm a huge fan of diversion agreements. When I was practicing law, I loved to enter people into diversion agreements if it was a good fit. Why? Because the case would be dismissed. They'd have to go do something stupid like an 8-hour class somewhere. Yes, okay, I'll go take an adult responsibility class, and next time I'm out in Old Town Scottsdale, I won't throw a beer bottle at the wall. Great, thanks, right? Charge dismissed? Yeah. Can you go sit there for 4 hours? Yeah, great. Perfect. Done. Gone. But that's that situation, okay? Someone threw a beer bottle at a wall. Someone's not an international, money laundering, bribery, human trafficker doing Lord knows what, right? It's a whole different ballgame there. Using a diversion agreement for this type of stuff was insane. And it would just automatically immunize that. That's like somebody throws a beer bottle, you give them a diversion, or urinating in public is a good diversion crime, okay? You were out, you couldn't find a restroom, urinated in public, okay, don't do it again, we'll dismiss the case. Not this, where you say everything you've done for the last 4 years involving international trafficking is all immunized, right? That's insane. So, but they did it, and they wrote it into a document. The DOJ did. I can't even believe it. Anyways, if the court believes that the parole evidence should be considered outside evidence, Mr. Biden requests an evidentiary hearing to talk about the diversion agreement. So if you doubt us, saying, Judge, if you doubt me, like, we've got emails. We've got a lot of people that can be called as witnesses to address this extensive recapitulation provided by Weiss. I totally believe that. I would bet that Weiss was waffling on this, probably political pressure from both sides. Probably Biden's people breathing down his neck. You got to dump this case, bro. And on from the other end, like, Congress is sending him letters, his whistleblowers, his DOJ, right? Everybody in the investigations looking at him like, are you serious? You're giving him diversion on this? Like, believe it or not, there are still good people in the DOJ and these agencies, right? And they're looking at this. They want to do good work. Like, they want to go there and serve their country and put bad guys in jail. And this guy's a bad dude. And they're going to give him a diversion deal. So Weiss is catching it from both ends. And now the whistleblowers are popping off, right? They're coming out now too. So with the parties' approval of the diversion agreement, Hunter's defense says, and a 24-month diversion period began. He's like, I started it. You guys may not have started this, but I'm starting it. If Hunter complied with his obligations, the prosecution would not bring new charges against Biden for his past conduct, and proceedings on the information would not be pursued. And that's lit, like, they brought a whole new set of charges in California. They say within 30 days of expiration of the diversion period, the prosecution would then dismiss the indictment against Biden if he satisfied the diversion. But the government contends that the diversion period did not start until the probation office signed the agreement, right? Government came back and said, look, we signed it, you signed it, Hunter signed it, but probation didn't sign it. And they're the ones who monitor diversion, and so they're the final say. But they say, we don't care about that. We say the probation office, even though they didn't technically sign the document, and this is insane that we're dealing with this. Like, I can't tell you, like, this is like malpractice from the government, honestly. They're maybe going to lose the entire case in both cases, essentially, because they may have articulated an immunity deal that just barely got approved by a probation officer's signature. Like, you know how lucky that is? That they just didn't just throw it over to the guy? All right, just sign it. Just take it down to probation. It's like in the same building. Just walk it down there, get it signed. It's nuts. If it's not intentional, okay? That's my point. It's like these are not dumb people. They know what they're doing. They're trying to squeeze this through. And they couldn't squeeze it through. So now Hunter is telling them, like, you've already done it. Like, sorry, you've already given me the deal. Nothing you can do about it. So they say probation already approved it, even if they didn't sign it, which means the agreement is binding. Saying ever since Biden entered into this diversion agreement 4 months ago, he's complied. He agreed not to exercise his Second Amendment right to a firearm during diversion, right? He's already suffering consequences. He's already basically serving his penalty. Therefore, you can't take away the benefit if he's already serving the penalty, which he could otherwise do because he hasn't used illicit substance in more than 4 years. Yeah, right. Bro, they just found cocaine at the White House. Mr. Biden is subject to a host of other conditions, including agreeing to supervision by probation, and he's doing drug testing. Now, in return, the prosecution stated that Biden is entitled to immunity for that, right? It's an exchange. There's consideration there. And he's entitled to immunity for conduct described in the statement of facts in the diversion agreement, meaning you can't charge him. In particular, the prosecution told the court that this provision, they said, would prevent them from bringing charges related to this case. And remember, the statement of facts was massively broad. Says it relates broadly to gun possession, tax issues, and drug use, right? But here's the problem. Now, on July 26, the same day that they signed the diversion agreement, Mr. Biden also entered into a plea agreement. Now, unlike the diversion deal, the plea agreement required the court to approve it. And so it did not become effective because the court did not accept the plea. But it's important to recognize that they are separate agreements. By its own terms, the diversion agreement, which is just between the government and Hunty and apparently probation, they made clear that that constitutes the complete and final agreement by the United States and Biden on this matter. There are no other agreements, written or otherwise, that modify the terms. If the defense attorneys win this, man, they squeaked it through. It's crazy. But the validity, and they squeaked it through because the DOJ was complicit in it. And any of this is just after the fact, trying to paper up over what they allowed to get through. And they had to backpedal on it in front of the judge because she busted them. Like, no, that's not exactly what we meant. The validity of the diversion agreement did not depend on the court's acceptance of the plea agreement in any respect. So we don't care what you did with this case. So Hunter even didn't get the plea deal, okay? They're saying, Hunter, the diversion deal is just done. And you don't even get to bring the Delaware charges, right? Sorry. And it's amazing. So with no hesitation or qualification, the prosecution agreed with the court that they are separate and that the plea agreement stands on its own. And Biden's lawyer at the time said that the parties have taken the position that the diversion deal is separate and it's a contract between the parties. And the validity of the diversion agreement was not an issue before the court. In other words, Judge Norica in Delaware, you don't even get to decide on that. We're not asking the court to rule on it in any way. It's like a private contract between the two. It's amazing. So they say here in this footnote, the court deferred its ruling on accepting the plea deal, didn't decide whether it's appropriate or not. Now, the court did question how the immunity provision of diversion would work. Saying, I'm not saying how I'm sure you're going to breach or not, but they're talking about what happens if it breaks down. Now, Hunter's team says, even before the hearing, the government expressed in its agreement that the diversion agreement resolved the charge about all of this. Hunter's lawyer proposed saying that they concluded the prosecution's investigation, but the prosecution in their press release wanted to say resolved. And so they're defining what that word means. Now, they say Judge Norica, all sides recognize the diversion agreement remains in effect. Using the present tense, the prosecution even told the court, said, Your Honor, because they were trying to cover this up too, a diversion agreement is a contract between the parties, so it's in effect until it's breached or a determination of a breach has been made. And Hunter's lawyer told the court, I want to be clear. Our position is that there is a diversion agreement that is binding. It's a bilateral contract and we are bound by it. Now, even when pressed by the court as to whether Mr. Biden would challenge the gun charge, his lawyer responded, said, Your Honor, I can tell you our intention is to abide by the agreement and honor the agreement. If somebody tries to bring charges, we're going to say you can't. We're immune. But now the prosecution seeks to backtrack on this. But the plain language of this and everything that they said during this, including Hunter's lawyer's statements, all show that the prosecution cannot bring new charges, saying that this is unambiguous. It's enforceable. Supreme Court has recognized this. It is executed by the parties. It explicitly states that the only parties are Biden and the prosecution. So the probation department didn't even need to sign off on it. A lot of case law here. Because this does not make the agreement is effective, right? Now, they say if it's ambiguous, if we have questions about this, you got to construe it in Biden's favor. Not only did we all sign it, but yeah, it is a little bit confusing. And so if you want to search for ambiguity here, the rules say you got to give it in favor of the defense because the government should know better. We're not going to prejudice the defendant. Hunter's already been not using crack. He's been put out. So it was the prosecution that pushed Mr. Biden to adopt this. They said it was your deal, man. You were the ones who offered us the deal. He is rubbing their faces in it. It's pretty incredible. I'm sure they're very upset with him. Now, Mr. Biden gave up rights and agreed to the prosecution's facts. It's fundamentally unfair to make him concede on these things and then to retract the deal. And so they say that the court is now being asked to consider the diversion deal in effect and dismiss everything else. They say probation was not a party to this agreement at all. They are not a party. They don't need to sign it. The diversion agreement would have stated that a signature from probation was necessary. Here, it must be signed by, they say, by the United States, by Biden and Biden's lawyer. And they're just referencing where they think that that is sufficient. And probation approved the diversion agreement. They actually said that they recommended the diversion agreement. So it's just a technical thing. They didn't sign it, but they were on board with it. And so you cannot reject this from Hunty Poo now, because Mr. Biden, one party, struck a deal with the government, and the other party, through the diversion agreement, as part of that agreement, Hunter sacrificed valuable rights here. And so they now are trying to take political cover from criticism that they got levied against it, but they're not entitled to change this agreement. And so you should dismiss this indictment signed by Abbe, Lowell on behalf of Hunter. And so he is literally rubbing their noses in their own rigged deal. This is the exhibit that they submit. The declaration of Hunter's lawyer, Christopher Clark, rubbing the DOJ's nose in their plea deal. He says, hey, I was the lawyer back during the time when the rigged plea deal got botched. I represented Hunter. I'm a member of the bar in good standing. He says, I want to tell you about this plea deal, diversion deal that we all worked out together. He said, back in May, one of the lawyers for the government emailed me and our team. They said, hey, Attorney Weiss has full authority to bring charges in any jurisdiction he deems appropriate, which confirmed that he operated with the law. Now, that's an interesting comment. Now, on May 15th, then we got more emails. Look who sends emails over to Hunter's team. Leslie Wolf. Remember her? The same one who already tipped them off about the search of his storage facility. She initiated a phone call when they indicated that the U.S. Attorney's Office was willing for a non-charge disposition. Okay, no charges for Hunter in May. Nothing. Zero. Nada. Non-charge. Don't even charge him to resolve this. 2 non-negotiable requirements. Further confirmation by Leslie Wolf, again on May 16th, that there was another openness to a non-charge, non-plea resolution. Don't even charge him. And so he flew to California. He went out there to actually meet with Hunter to explain the proposal. He's like, great news, man. They're not going to charge you at all. He's like, you're kidding me. Amazing. In the morning then, the next day, on May 18th, while staying at my mama's house, says Christopher Clark, and prior to meeting with Hunter at his home, I called U.S. Attorney Wolf, Leslie Wolf. I called her on her cell phone. I said, hey, Les, are you sure that you can confirm that before meeting with Hunter that David Weiss is open to a non-plea, non-prosecution deal? Wolf says, yeah, I'm sure, man. We don't want this thing going anywhere. Yeah, I'm positive. So that's bad form, right? If she promises him something, you take it to your client. He then met with Hunter that day to discuss the concept and the terms. It's like, it's a great deal. 100% you have to take that, like all day. Later that day, my co-counsel emailed Wolf a draft of a non-prosecution agreement. These guys move fast. They're like, yeah, let's take it right now. Let's go now. An initial draft statement of facts for the purpose of facilitating further discussions. The non-prosecution agreement would apply to Mr. Biden and to Owasco, his companies. A true and correct copy is attached. So they have the receipts, okay? Their collusion with the DOJ, you call this plea negotiations. I'm going to call it collusion because Wolf was warning them, like, this is not normal prosecution stuff. On a phone call later that day, while I was still in California, and after I had already met with Biden, then Leslie relayed to me, David Weiss changed his position. He says, nope, no more non-prosecution agreements here. Instead, we're going to do a deferred prosecution agreement. All right. And deferred means we are going to prosecute you, but we're just going to delay it. And if we delay it and you do the things that we've asked you to do, when we revisit this decision later, we will decide not to prosecute you. Right. So it's a little bit more of a process rather than, there's actually some process. Now, I expressed my dismay to Wolf. I said, how could you do this, Leslie? I just talked to you like yesterday. What are you, nuts? You just told me this. I'd be furious. I just went to my client. I flew out of California here, man. The place is a dump. Hunters, hang with crackhead friends over here. And now I already explained it. He's already changed his position. I've already confirmed this with you several times. So I said, all right, fine, look, we'll do that. I can talk him into it. But what is this deal? I asked Leslie Wolf whether or not a deferred prosecution agreement would include a plea by Mr. Biden, or could we do it without a plea? In answering that question, she said the agreement was unclear. Weiss didn't even know, idiots. And that she would check with him. I don't know. What do you mean? Oh, they don't even know what they're doing. So during that, So during that same phone call, Leslie Wolf, who's in California, she assured me that a deal would get done. She's like, don't worry, we're going to get this through. I've been working with you guys for years now. I hate Trump. Biden's the man. And that the office had several people working on it. We're all trying to rig this thing. And that it would not be finalized before the weekend because David Weiss now wants to change this. Now, at that point, given what Wolf and I had discussed, this non-charge resolution was conveyed as another official offer duly authorized by Weiss. And so I said, hey, this deal must close any and all investigations of Hunty. And I said, Wolf, send me the new terms. I flew back to D.C. from L.A. So in an email that same day, Leslie Wolf stated that the U.S. Attorney's Office would, quote, consider a pretrial diversion agreement in place of a non-prosecution agreement, and listed key terms of the deal, some of which included a draft non-prosecution agreement that day. Wolf listed 10 terms. Agreed to waive an indictment, information on this, agreed to dismiss after 3 years, right? The case would ultimately go away. Diversion will be public record, more comprehensive statement of facts, blah, blah, blah. The terms set forth came out. I reviewed the terms with Mr. Biden, and Biden said, yeah, I'll take it. Obviously, like all of it's going to go away. Now, where Hunter botched this is because he should have just taken the deal. It all would have gone away anyways, but he wanted it in writing, which I think was a dumb move. Now, in furtherance, the U.S., because they wouldn't have prosecuted him again in California if he just would have taken this deal. In furtherance of, in my opinion, in furtherance of the U.S. Attorney's preference for a diversion agreement rather than a non-prosecution agreement, Hunter's team says, Wolf then sent me some documents and we appended a copy of it. We got a notice from the court. Here's a copy attached. Like they sent me the deal. Here it is. And with Wolf's direction, then I used the terms and the model for the diversion agreement. My co-counsel sent it over to them. And the following week, then Wolf and Hudson, then they called me to tell me that Weiss changed his opinion again. And that he's no longer going to agree to a plea deal until there's some type of a plea by Biden. Now, according to Wolf and Hudson, Weiss is now requiring a resolution to include pleas to 2 failure to misdemeanor charges. And following that call, I said, hey, Leslie, this is crazy. I called her at 4:14. Now, that same evening, Wolf reiterated in a follow-up email. She said, okay, listen, Weiss ultimately did not approve the continued discussion for diversions related to tax charges. And she says, what? That's a total change. You already sent me something back on this in May. So it's like, he's like, I've got the emails. You want to see them? This is a copy of Wolf's email to Clark, copying Hudson. It's attached. Here it is. He says, I discussed this change with Mr. Biden. I had another phone call with Wolf. I said, okay, we'll go forward on the new deal, but please don't change the terms again. Now on that call, because look, these guys had a smoking deal from day one. Okay. Like this shows you how incredible the first deal was. Do you know why? Because they're taking the second best deal and the third best deal and the fourth best deal. They're like, yeah, we'll still take it. Yeah. Like we still want it. Yeah, I know, but it's like $10,000 more. I know, but we'll still buy it. Because it's that valuable. Okay, fine. He's got a plea. Fine. Okay. Plea deal. Fine. Okay. 2 charge. Okay. No problem. But it's immune. It's final. Everything else is done. Okay. Let's go. Now on that call, I communicated to Wolf a critical requirement. I said, Hunter cannot go to jail. She said, oh, are you nuts? Yeah. We'll do probation for that. Deferral agreement. Wolf said, let me check with Weiss. Yeah. Now, next day during a phone call, Wolf relayed to me that Weiss would not be inclined to accept this type of term. So I decided to take it back to Hunter. Now, in the days following, they then discarded their prior agreements, their non-prosecution, their deferred prosecution. They substantially rewrote a diversion agreement and they filed it later, or they sent it back. She sent me an email, invited me to her office, said that we're going to be in the same room with Weiss and we're going to work it out. So then co-counsel Matthew Salerno and I, we flew over there. Then I saw their draft agreement. Wolf expressed to me that it was in Biden's interest to have a broad statement of facts, okay? We want broad facts. Don't get into details here because we're going to just tuck a bunch of garbage in there. Like you make money in the madness. You've ever heard that, right? There's a lot of grift in the gray area, right? You can really, really squeeze a lot of stuff through if you don't know exactly what's in there. So leave it broad. Just say he was a crackhead from 2000 this and 2000 that. That's it. And they did that. We read it. The agreement would be a more limited immunity provision than I had discussed. But During a couple meetings, specific references to tax liability for other years were specifically added, right? So the defense lawyer's doing great work, making sure he's totally covered. U.S. attorneys, we took turns. We worked the specific language of each agreement, right? This wasn't just a sham deal. I mean, it is a sham deal, but there wasn't like a cobbled together deal. Like they were all in on it, and the judge busted them. Wolf running the changes by office leadership, including Weiss. No final agreement was reached that day, but we continued to work and compose the language. Now, that same evening on Friday, I emailed Wolf, copying my co-counsel about this. And in the language, they said the United States specifically agrees not to criminally prosecute Biden outside the terms of this agreement for any federal crimes arising from the conduct described herein. Again, the very broad language. In the email, I said to Ms. Wolf, I said, look, it's very critical for us that the diversion agreement include this language or its equivalent. Now, on June 5th, Wolf sent me the revised drafts. They look pretty good. Now, the draft that we discussed previously, but I rejected the edits that I had proposed. Rejected the edits. In their draft, they instead provided the following. They said the United States agrees not to criminally prosecute Biden outside of the terms of this agreement they inserted for any federal crimes described therein. Okay, so they narrowed it a little bit. So he says, I don't want, no, that's the same thing. Okay, here attached in the statement of facts and his exhibit. Okay, so he's attaching it all here. Now, by this point, they had assumed full drafting responsibilities over the agreement, right? The structure was new to me and my co-counsel, something we never suggested. So now he's going to feign ignorance here. And so we told them what we wanted. We said it's absolutely critical to us. They redlined this. A true and correct copy of the emails are attached herein. And this defense attorney is doing good work, man. He's just papering the record. Now, Wolf assured me and co-counsel that the format that they were structuring would address these resolutions. Now, I repeatedly discussed this with Wolf and Hudson. I said this is an essential component of any plea deal. After extensive discussions with Wolf, in which he repeatedly stated that Weiss was unwilling to revise the language of the immunity provision, I conveyed that if this language could not be revised, we would not have a deal. And that it was the most important term in the agreement that Biden get finality, right? Digging his heels in on that. Now, accordingly, I requested, I said, I got to speak with Weiss. Like, there is no deal if it's not here. Now, I was told he was the person deciding the issues of the agreement. So later that afternoon on June 6th, I spoke with Mr. Weiss. I talked to him. During that call, I said, listen, David, the agreement's immunity provision must ensure that there would be finality and closure of this investigation. I told him that repeatedly. I also conveyed to Weiss that this provision was a deal breaker. If we don't have this deal, it's over. I noted that Weiss had changed the deal several times. I said, you keep changing the terms, brother. And I could not have this issue be another one where we had to compromise. We'll change on anything else, but not that. So he said, what's the problem with the proposed language? I said, listen, the immunity provision, it must protect Biden from any future prosecution by the U.S. Attorney's Office in a different administration. Like if Trump comes in, I got to get him protected. He said, oh, yeah, that's right. Trump, I forgot about him. So the attorney considered the proposal. He said, he'll get back to me later. Right. So David Weiss, the guy who's supposedly in charge of this thing at the time, is now considering it. Now, later that same evening at 5:47 p.m., Wolf emailed me the proposed language of the immunity deal. Wolf says this, all right, you guys are being a pain in my butt. But how about this? We'll include this. The United States agrees not to criminally prosecute Biden outside of the terms of this agreement for any federal crimes encompassed by the attached statement of facts and the statement of facts filed the same day. Encompassed. See how this is going? We're getting some very strange terms here. Encompass. All right. Says now, after speaking with Biden, I responded to Wolf that the language she sent me works, right? Now, we're still like, it's very questionable. We're just covering something up now. Suitable for us. I can make it work. At which point the parties had a deal. So that if this comes back, like if Trump prosecutes Biden later, for example, on the actual crimes that you see in the reports, he's immune. He can go back and say, Judge, look, it encompasses all of this. We're safe. And he feels good about it. He sells it to Hunter. So a true and correct copy of the email is also attached to this, saying that on June 7th, we then had the revised draft of the diversion deal. It said the United States agrees not to criminally prosecute Hunter for any federal crimes encompassed. A true copy of the email is attached. This is the same language that was in the document, and consistent with the conversations with Weiss and Wolf, I saw closure for Biden, and I communicated those to him as well. Then, on June 8th, government prosecutor Hansen, Wolf, and we began making arrangements. We got approval, we got probation lined up, we got pretrial services lined up, we got an interview of Mr. Biden with probation lined up. It was all scheduled, and here are my emails to them. But then, on June 9th, when the courtroom deputy communicated that they would prefer to set the schedule once the documents are filed. We couldn't complete the probation paperwork early, so we got to wait till it's done. Then I had a phone call. I emailed Government Hansen a proposed press statement to accompany the public information charging document that's being released. Now, he said in his release that he wanted to say, I can confirm that the 5-year-long extensive federal investigation into my client Hunter has been concluded through agreements with everybody. Now, shortly after that email, I got another phone call from Hansen. She says, well, we got to revise that language, okay? I want to say the investigation is resolved rather than concluded. So the government wanted us to think that this was still open. Like, we're still investigating this and there could be possible charges, blah, blah, blah. And so they just wanted it resolved. But Hunter's people built in immunity that they just agreed to, as we saw. Now, I then asked her directly whether there was any other open or pending investigation. She said, well, concluded. Is there anything else? Why can't we say concluded if it's concluded? And she says, no, there's nothing else open. We just want to scam America and just tell them that it's resolved so that Jake Tapper can come out and say, well, they didn't say it's over yet. So they say, okay, well, I sent Hansen a revised statement, said that here it is my understanding that the 5-year investigation is resolved. All right. Now, the new revised language change concluded to resolve, but they meant the same thing, right? It was done. So she says, in accordance with these language that we've entered here, this was ultimately adopted. I had the U.S. attorney, the diversion agreement. It was not conditioned on the guilty plea. We said it was effective regardless of what happens with the other document. On June 19th, government prosecutor Hansen emailed me, copied Leo Weiss, Derek Hines, and Wallace, none of whom had been involved with any of this prior, and sent it over to them. Then we looked at the agreement. We had our hearing scheduled, and we showed up. Now, on July 20th, probation and I made final changes to the probation deal, or to terms. We were talking about emails. When are they going to meet? The diversion agreement that they sent reflected the agreement that Hunter had a 24-month pretrial diversion program managed by probation. And at no time following the execution of the agreement did Biden agree to rescind the agreement. So that is all declared under penalty of perjury. Christopher Clark, Hunter's lawyer, signing off on that. And he is just exposing the rigged plea deal that the DOJ tried to cram through, right? They changed it, bottled in the immunity, gave him exactly what he wanted, and the judge basically caught them. And then when the judge asked Hunter questions about this, he said, I do not necessarily understand it. It's not what I agreed to. This is an unwritten deal, okay? This is an unwritten agreement. If Hunter would have accepted the plea deal, I do not think he would have been charged again. And he would have been able to claim that this immunity deal covered him. He's claiming it now, but if he just would have taken the deal, he could have claimed it later. So they kind of botched that there at the end. I think it is amazing that this has happened the way that it has. What's even more amazing, though, is that Hunter is digging his heels in and now attacking his dad's own DOJ as being corrupt and unethical, which, of course, we know they are. So it's interesting to see Hunter even saying that now. Now, this is his lawyer, Abbe Lowell, and these are people who've already been given like 50 bites at the apple on this thing, and they still want more. They want no charges. They want the whole case gone. And here's what it sounds like.
Your point is well taken, sir, but let me ask you, what have they said to you? What did prosecutors say to you and to your client as to why things changed?
That's a really good question. So they said nothing. Indeed, this was a complete surprise to us, notwithstanding we had been in contact with them. Indeed, I think about a week ago, I called the U.S. Attorney's Office for a status check so that I could come in and talk to them if they had any idea that they wanted to bring any additional charges after the gun charges. And at the time of that telephone conversation, they said, no, you already had that meeting. Well, that was based on their investigation years ago. So I said, I want a new meeting. And what they said was, well, we don't know we can do it. I wrote a letter both to David Weiss and copied the Attorney General saying, if there's any new evidence, then we should come in and address it. If there's no new evidence, then how can you justify anything other than what you did in June? And their response was first silence and then the indictment without any communication back to me. You know, again, if I've done this work, I am in the defense bar. That's not the way it works. Prosecutors engage with defense attorneys to discuss the investigation and the possible charges.
Not when they're mad at you, man.
It's just yet another way that Hunter's been treated differently than others in similar circumstances would be treated.
No, I think they goofed, right? They were given a deal by the DOJ, which was tiptoeing around this. Like, please don't make any loud, sudden movements. Please don't make any noise. Just take the deal. Just shut up. Nobody's going to charge you, okay? And we're going to wrap in immunity there. So once you just get it entered, then you'll always be able to claim it. But they couldn't get it done. Then they started swinging at the DOJ. Now the DOJ is really not playing around. And my question is, are they going to hit him again to really shut him up? This could backfire badly for him. We'll see. Or not. It could win. He could say, no, totally immune. And the DOJ rigged it anyways. But the DOJ will then have a very, very black eye at the result of if that happens. So I don't think that they can let that happen now. They have to save face as an institution. They can't have Abbe Lowell going around and saying that they're a bunch of corrupt hacks, basically like he's doing today.
Abbe, it's Jennifer Palmieri. When you say that Hunter's treated differently than others in other circumstances, that is because his last name is Biden? Is that, I mean, this is what we are talking about? Well, yes and no, Jennifer. Yes and no.
I mean, it's because his last name is Biden, but it's not like they're going after, you know, some distant cousin. It's because he is the son of the president who's named Biden. The Republicans and anybody else that's been investigating on the right-wing media, for example, have tried and tried to say that President Biden has done something wrong. They can't find a shred of evidence because he hasn't. And yet they want this to be an issue. And what they've successfully done, because they go out on the airwaves and people don't understand the difference between truth and misinformation, is basically saying, okay, I can't get the president, so I'll besmirch his son in a way to suggest that there's something going on between the two of them. That's why it is because his last name is Biden, because of his proximity to his dad, who has been a supportive father to his son through all the best and worst parts of Hunter's life.
Yeah, the reason he's been able to get away with all of this, the reason why he's been able to be a crackhead for most of his adult life as a 50-plus-year-old man who's basically accomplished nothing other than grifting off his family name, is because he is a Biden. Anybody else who is engaged in this type of criminality, this type of overt tax manipulation, would have been charged a long time ago, probably in jail already. So the benefit that he is getting is simply because he is a Biden. If this was any other case, he'd be prosecuted much more harshly. And in fact, now that they're getting ornery about it, it seems like they are raising the specter of much more serious charges. And so, very interesting thing that's happening. It is wild to watch this little, intra-agency fight. It's Biden versus Biden DOJ. I mean, it's a wild scene. So we'll be here continuing to cover this, my friends. There was a slew of other motion in the Hunter case. Thank you for subscribing. Thank you for checking out our new shop to grab a hat, grab a t-shirt, grab some Hillary Clinton sandals at robertgovea.com. Your feet will be very lovely and supported on the faces of our leaders. So check them out, robertgovea.com. Thank you for subscribing, and we'll look forward to seeing you on the next one. All right, my friends. And now let's check out our final segment. On the day, we've got some pseudonym emails. 1,700 plus Biden alias emails now going over to James Comer, courtesy of our friends over at NARA, the National Archives. The head librarians there, you may remember them from the Trump case in Florida or from the missing January 6 documents. But now, as part of a request, Comer's investigating the Biden crime family. They've got 1,700 new emails that apparently include some of Joe Biden's conversations about Ukraine with Hunter, many of them using aliases, pseudonyms. And so this is what Comer posted on the X platform, saying that there is a lot of shell companies that were involved in these different communications, saying, look, GOP oversight followed the money, and we've identified 20 shell companies created by the Bidens. They raked in over 24 million from China, from Russia, from Ukraine, from Kazakhstan, from Romania. And what were they doing to get all this cash? Who knows? But look at them here. We've got RSTP2 Bravo, Owasco, Alpha, Inc., Lion Hall, Rosemont Seneca Bohai, Owasco, Robinson, Skinny Atlas. Thank you to Garrett Ziegler for the pronunciation on that. Seneca Global Advisors, and around the clock we go. A lot of information there. Now, this is something that the Oversight has been digging into for some time, and the National Archives is giving them a nice trove of information. The Daily Caller got the letter. They tell us that NARA is giving Comer access to over 1,700 emails from Joe Biden's vice presidency, and some of those are some good ones, supposedly, saying that 1,799 emails, or 62,000 pages of records in total, are tied to Hunter Biden and his business dealings with Burisma. This is the agency, this is what they said on Monday, and we'll read through the letter there. Now, Comer already wrote a letter asking for unrestricted special access to these materials as part of email pseudonyms that then VP Biden appeared to use for government purposes. Why would you need fake names for 1,700 emails? Now, this was related to case number 2023-0022-F, which appears to contain records related to Hunter Biden and to Ukraine. Now, in September, Comer followed up with a letter. He's been demanding access for a long time. His letter cited archived emails that were between Hunter's former business partner, Eric Sherwin, and members of Joe Biden's staff in 2015 when they were collaborating on a response to questions from the media about Burisma. Now, the Biden administration did give Oversight access to a few pages of records, like emails praising Joe Biden and his son Beau, but NARA said in October that they had 82,000 potential records tied to Joe Biden's pseudonyms. 82,000 of them. They said on Monday, we're going to give you some of those. Here's what the letter looked like from the National Archives, Office of the General Counsel. You see drafted December 11th, written to the Honorable James Comer on the Oversight Committee. They said, all right, James, via email. Dear Mr. Comer, this is regarding the second interim release of records that you sent in response to a request. Dear Comer, now I write in response to your August 17th letter saying that you want access to certain presidential and vice presidential records from Obama. The request is being processed in accordance with the Presidential Records Act and U.S. Code, which provides for an exception to restricted access to records that are requested by any committee or subcommittee of Congress if such records contain information that is needed for the conduct of its business. As well as under NARA's regulations and executive order the following, we have decided that we will work with you. You have requested the following records, James. 1. Complete and unredacted versions of all documents from case number exhibited here. Any document in communication which is a pseudonym of VP Joe and was either included as a sender or recipient, whether he was copied, or whether he was included in the contents of the documents for these pseudonyms: Robert Peters, Robin Ware, JRB Ware. And any document or communication in which Hunter, Eric Sherwin, Devin Archer was included either as a sender, a recipient, copied, or was included in the contents of the documents. Similarly, all drafts from November 2015 to December 2015 of VP Biden's speech delivered to the Ukrainian Rada on December 9, 2015. That's curious. His speech. Now, as we've explained to your staff, says NARA, we are conducting a rolling notification process on former and incumbent presidents. and the representatives have completed their review of an additional portion of responsive records, and NARA is now able to provide the committee with the following records described here. 1,799 emails and attachments totaling 62,000 pages. Whew, man, that's a lot. 62,000 pages. What are they talking about in pseudonyms? Are those all like spam filters? Like, did they just create like a spam email account when you sign up for those newsletters? Whatever, at gmail.com. Who cares? Or are they scheduling birthday parties for the Biden families and they don't want anybody to know about it? Huh, weird. 62,000 pages of it. It's a lot of birthdays. So the records will be provided by a secure web-based file sharing portal, hopefully uploaded right to the internet. And my colleague will send the link separately to your staff. Can you send one to us too, please? Thanks. Now, please note that some of these records contain personally identifiable information, perfect, including addresses, phone numbers, and other non-public information. And so we ask that you protect the information from public disclosure. Okay, we'll wait a minute until they black those out. And we're going to continue to keep your staff apprised of the status of this request, signed by Gary Stern. Thanks, Gary, for the records. Sounds good. We're looking forward to reading those. They also copied Jamie Raskin over in Congress. So that is what the latest NARA release looks like. James Comer is pretty excited about it. He says the investigation must expand. We are getting more and more data by the day, and it's time for us to open this up. Here's what Comer sounds like.
Important House Ways and Means Committee
is one of many crimes that Hunter Biden has committed. We believe that if you're going the tax evasion route, not only did he evade taxes on the obvious income that Weiss charged him with, but also the loans, and that's something that Jason Smith and the Ways and Means Committee are looking into as well. We believe that if you look at the loans that Jim Biden and Hunter Biden had, there's over $13 million in loans and no trace of principal payments, much less interest payments. So at what point does a loan become income? We believe there's significantly more tax liability than what he has. We also know that there's money laundering. We get that from all the suspicious activity reports. Most of the 170 suspicious activity reports at Treasury implied that the Bidens were money laundering. And from what we can look at with their bank statements now and the research we've done, I can confirm it sure looks like money laundering to me. You also have the obvious violation of the Foreign Agents Registration Act. And who was he lobbying for? He was lobbying for China, Russia, and some of the worst countries in the world.
Perfect.
But also, he was lobbying his father. So that makes Joe Biden liable in Foreign Agent Registration Act liability. So we've got a lot of concerns here. This is the tip of the iceberg. I'm not surprised it happened before this week, but this case is far from being over.
How much money are we talking about, Congressman?
Well, we know they've gotten over $24 million from our enemies around the world. Now we're finding all these loans. Jason Smith just released the parts of the transcript from the whistleblowers. You've heard John Solomon break the story that there's an additional $3 million that he may owe Kevin Morris. What are the terms of that? Is he ever going to pay it back? If you have a loan for years and years and years and you don't ever pay any payments on it or have any intention of paying it back, then that's income. If you take $13 million in loans that we've identified with the president's family, that's another $4 million in federal income taxes that they would owe, in addition to evading taxes. I mean, there are many, many problems here, but at the heart of this is Joe Biden. All of this revenue came because of Joe Biden. Joe Biden knew what his son was doing. He knew what his brother was doing. He met with all the people, even though he said he never met with them. He continues to lie about it. He did it this week. This is a concern. We fear this president is compromised. We know he's been dishonest with the American people, and that's why we're pressing forward with the impeachment inquiry next week.
All right, and we're looking forward to seeing what happens on that impeachment inquiry. We'll see if the Republicans have the votes. Steve Scalise says that he thinks they do. He says it's looking more and more like it is acceptable to the Republicans. Here is what Scalise sounded like when he was talking about it.
Yeah, well, the first thing that we've been doing is collecting evidence, and you've seen this with multiple committees. Jamie Comer's committee, the House Oversight Committee has been doing the bulk of the work. Jim Jordan's committee, Judiciary, as well as Jason Smith's Ways and Means Committee have also brought witnesses forward. But you've seen an array of items come forward. Obviously, all these shell corporations, the millions and millions of dollars that have been identified, checks going into Joe Biden's account. Ultimately, the White House has changed their story multiple times, but there's still more evidence we're trying to get, and the White House is blocking that evidence. That's why we need to exercise more subpoena powers, and having this vote on impeachment inquiry gives us the best opportunity to get more facts out, to continue searching, to ultimately let the people see what's really going on with this investigation and let it lead to ultimately where the facts continue to come out further.
And they'll time it right in alignment with, theoretically, the election cycle, which is perfect because they're doing that with the Justice Department. And so the Republicans are playing the same game. Byron Donald says, look, more and more people are thinking this is the right move. They've already expelled Congress people from the Republican side for conduct much less serious than anything alleged against the Bidens.
What I will say is that we just had a vote a week ago where we expelled George Santos. Now, I did not vote to expel George. I felt George should have had his day in court. But if you're going to take a vote to expel George Santos based upon the Ethics Committee report, then you should easily be able to vote for an impeachment inquiry based upon the investigation that's been brought forward by the Oversight Committee, the Judiciary Committee, and the Ways and Means Committee. Because with all due respect, with everything that happened with George, and the accusations are not good, but that pales in comparison to the accusations that have been leveled and the evidence that has come underneath those accusations against the Biden family. So I would urge all of my colleagues to vote for that impeachment inquiry this week. The precedent had been that either you were in the Confederate Army or you were convicted in a court of law. That did not happen to George. So if the new standard is allegations and ethics complaints, then Bob Menendez needs to go.
Yeah, and evidence continues to mount. We've got now 1,700 emails that will be working their way over to Congress and James Comer and the Oversight Committee, and we'll see what is inside. Maybe there's perfectly good explanations for all of those emails, 62,000 pages of pseudonym emails being used on government accounts. Don't know what that might be for, but seems like there is probably a reason why you don't have those when you use government accounts, so that you can keep records of the things that you say. Why they're doing that, time will tell. Impeachment inquiry will be marching forward. We'll be here continuing to cover, my friends. Thank you for subscribing. Thank you for checking out our new shop at robertgovea.com to grab yourself a hat, grab yourself a watcher hat, or some new sandals over there at robertgovea.com/shop. And we'll look forward to seeing you here on the next one. All right, my friends, that is it for us on the day. We covered some good ground. 1,700 Biden alias emails now going over to James Comer. Hunter Biden is exposing his plea. I'm still proud of that one. Says that I said that the DOJ rigged his immunity deal, and we all got to read through that one. And now Jack Smith also apparently has access to Trump's cell phones and some of the Trump records. All was on the show today. But now, my friends, let's hear from you, and let's see what you have to say about this over from our friends on the Rumbles, the YouTubes, and of course, watchingthewatchers.locals.com. We do members-only streams over there, and so we do streams in the morning and on Saturday, and so come check us out, watchingthewatchers.locals.com. Let's see who is in the house with some very nice, lovely donos here. We got Crash shared a nice toilet image, which we'll skip. The Chugi Show says, well, you have some explaining to do to my father, says the Chugi Show. Been a supporter for 3 months. Thanks to the Chugi Show for being a good membo. We have some other comments coming in from Catherine Rex. What's up, Catherine Rex? Catherine Rex is saying, some of us want TP with their faces on it. Some of us want TP with their faces on it. Oh, you mean for the sandals? Like toilet paper? I don't know. That's probably pretty expensive. Maybe you can afford it. I don't know. That sounds expensive. Glocky, it's a great idea, though. Glocky McGlockface says, Holder helped to facilitate the arming of the cartels, and ISIS made Obama it all executive privilege, so he was able to obstruct Congress when they asked for his testimony and docs, and yet there was no FBI raid. Yeah, no doubt at all. No doubt about that one. And Holder was just literally explaining what I think they're doing. Glocky says, so wait, Trump didn't try to conceal his location? Wow, seems like he's pretty horrible at this whole insurrection thing, conspiracy thing. DOJ's a bunch of clowns. I agree with you on that one. And you're right. Yeah, he's like sitting in the White House trying to insurrect the country, making Twitter videos. Okay. Wendy K says, Trump is smart. He had someone capture all his tweets. He has the receipts. I don't know what he's got. He says he's got some serious stuff out there. I think that the thing is Jack Smith has less than he thinks he has. They wanted everybody to think that this was a big insurrection and nobody's buying it. A bad poet, been a membo for 6 months. A bad poet, thanks for being a membo, says, I want to see White House staff, cell phone, and Obama's. Yeah, it'd be nice. Unfortunately, they're not being prosecuted. Shri is here as a new supporter. What's up, Shri? Thanks for being here. Thanks for joining as a membo. Hopefully we see you tomorrow on our members only morning stream. We got Knox Bierman is also here, and along with Object Class Keeter. Says, it amazes me that they say that without recognizing what is happening to Trump. Yeah, probably talking about Holder. I think Holder knows what he's doing. I think he knows what he's saying, and he's just being very sneaky about it. It's projection, right? It's just classic projection. Knox is here. What's up, Knox? Says, happy Taco Tuesday, everyone. I'm so far behind on this stream. I hate when my own cases get in the way of watching the circus. Yeah, I'm sure your cases are a lot more normal than some of the stories we're covering here, Knox. Knox is an attorney in Texas. Shout out to Knox. Hopefully you had a great day and your cases are going well. We've got this one from Daryl. Daryl says, we were told when 2000 Mules came out that the geolocation data is not precise or legitimate. Maybe they needed this expert. Yeah, that's an interesting point, right? I remember that. And well, look, it's the government, okay? Evidence is only good if it serves their narrative. Otherwise, it's illegal and they'll arrest you and throw you in prison for illegal memes. Wendy says, well, he said it, so he should remember what he said. And that's kind of a good standard of evidence, that you don't need to give them any evidence because you should remember it or something. NY says, Rob, can you pre-record some of your famous sound effects and sell them in the store? What famous sound effects? Do we have famous sound effects here? I don't know what you're talking about, NY. If I had any, maybe I would. Pinochet says, can Trump appeal the discovery decision when denied? Yes, he can. I mean, it's debatable. Technically, like the general answer is no, right? The general answer for criminal case proceedings that are in the middle of a criminal case is no. You would appeal a discovery decision at the end of the trial. Generally speaking, the judge would deny you discovery, you take it up later. And if you were entitled to the discovery, then you would have a new trial on it. But this is an unusual case, so it might be different, right? Because there's a concept called collateral consequences. If you have consequences that are outside of like the regular criminal proceeding, in this case, a presidential election, then the courts of appeals will consider that on appeal. But generally speaking, the answer is no. This is a Trump case that's historic and a first impression. So the answer is more likely maybe or yes, depending on how they bundle it up. But generally, no. B-Man says, I disagree. The Florida case is still concerning files he took before January 20th, 2021. I disagree that the case is still concerning. Yeah, because he took them while he was president. And so, yeah, I mean, I can understand that. I think that they're going to say it's obstruction that happened after the fact, right? It's obstruction. Now, I would agree that the taking of the files, you could say, was him declassifying it, right? The physical movement of the files is him declassifying it. He's the president. He doesn't have to fill out a form. If he has to fill out a form to move documents, then the person who manages the form is in charge of the documents. That's not how it works. You can read the opinion clause power. It says the president has the right to demand the opinions of his executives in writing, in the form of writing. And that's what those documents were. In my opinion, he can take those. He has the sole power to do it. No person from the deep state, bureaucracy, FBI, whatever, can supersede that, including Congress with their U.S. codes. He has the root power to take presidential documents. And the Presidential Records Act is not an amendment that supersedes that power, which is codified under the opinion clause in the amendment, in the Constitution. Thanks, Larry. Thank you for that, B-Man. Good question. Larry says, reminder that the Trump docs case is based on all of his official duties as POTUS because he didn't attend the inauguration and he left D.C. for Mar-a-Lago while still POTUS, meaning the POTUS selected the docs to transfer to Mar-a-Lago, not a former president. Exactly right, Larry. And it's another great comment. And again, I think that the argument will be that it's obstruction, right? That he didn't have he didn't have lawful possession of those. They requested them back. There was a subpoena to get them back and he didn't give them back. So obstruction happened after the fact. But the argument would be that the predicate offense, the underlying offense that leads to the obstruction is not a crime. So you can't obstruct something that's not a crime in the first place. In other words, he was entitled to have those documents under the opinion clause. They demanded them back. They had no right to do it. They came and took them. And so there was no obstruction. I love it, Larry. Good comment. And we'll see what happens. First things first, we'll get rid of the January 6th case and then turn our attention to Florida. Pinochet says, can Leslie Wolf be prosecuted for a tip-off and a plea by the DOJ? I mean, that's the problem. Who's going to prosecute her? For what? Malicious prosecution or obstruction of justice or something like that. I mean, the DOJ didn't even fire her. All right. The DOJ is like, great job. Probably gave her a promotion and invited her to the holiday party. You know, who knows? Spud says, every time I hear Abbe Lowell's name, I can't help think of A.B. Normal from Young Frankenstein. A.B. Normal from Young Frankenstein. I think that's a little bit before my time. Pan-seared Ribeye says SCOTUS could rule the classified documents case because Trump took the classified documents while he was president. He and the boxes left for Mar-a-Lago well before noon on January 20th. And yeah, and I think that would, right, that would, in my reading of it, like the president would, that's him, they're his. He's declassifying them. He's marking them presidential records. Whatever you got to do to make it true. It's the president. He's like Captain Jean-Luc Picard. Make it so. Mark Butcher says, go get him, Comer, over on the locals. Knox Bierman says, political toilet paper would make a hilarious gag gift. I'll look into it, man. I'll look into it. You know, I love these faces. You know, I think they're pretty funny. If I could find a nice vendor. And did you see like Bill Clinton is tucked away in here? Like, this is what's funny about the sandals is Bill Clinton. He's kind of like tucked away up in there. See Bill? They're nice quality. You know, they're nice quality. Good for taking the trash out. You know, good for, you know, the dog do. And your feet are going to feel supported on the faces of our leaders. We got this one from Rocky Waters says, minter than normal show today, Rob, in my opinion anyhow. Love this Hunter situation. Very, very, very interesting. I find myself becoming a Hunter fan of sorts. There's a lot more to see here. We may be in crazy upside down times, but there's no denying they're not the most interesting of times ever. I do love watching, capital W, best entertainment ever. Thanks, Rocky, and it's good to have you back, man. I know you were on vacay, or I think you were out working. I think you were on a business trip or something. So we're glad to have you back. Thanks for the nice dono. You know, it is, look, man, Hunter throwing elbows at the DOJ puts me in a real predicament here. You know what I'm saying? I mean, the guy's a piece of garbage, and, you know, I don't appreciate him as a contribution to society, you know, but the DOJ is also like, oh my gosh, like mortal, you know, nemesis. Like they're just the worst. It's like a behemoth. And so even in like, it's a beautiful traffic wreck. It's just a beautiful explosive wreck. It's Hunter versus the DOJ. These two just, you know, reprehensible institutions and entities just going at each other, spilling out all the dirty laundry all over the place. It's like, oh my gosh, you can't look away. Yeah, it's going to be fun. So good to see you, Rocky. Thanks for joining us and for being on back in the show. And we had this one. So let me see if I can read this first one from Crash. Crash says, Rob, if you remember, several months ago, I posted a picture of a bighorn ram 6,200 feet in the Chapadera Mountains of New Mexico. The area is very remote. The facilities were these as follows in the early days. Point is, if you want to be a prepper, good luck. An E-tool, an entrenching tool, and this image awaits. And so the image is kind of, you know, I don't know what it is. So we'll leave that one there. But certainly, I don't know necessarily that we're being preppers. You know, I think there's something that's like a category of itself. But I think that being prepared is a good solution, right? Being prepared is a good idea for whatever's coming, just in case, because you never know. And so, Rocky, thank you for that one. And Crash, thank you for that comment. And we're going to jump over to X to say hello to our friends on X before we go over to Locals, watchingthewatchers.locals.com for our members only after party. And of course, if you want to check out the shop, you can do that. The shop is available now. robertgovea.com. Click the shop. You can grab a new hat. You can grab a new shirt. You can grab the Biden flip-flopping Joe Biden sandals. You can grab the ungovernable shirt. If you want to read more about the Watcher and what the symbol means, it's all here on display. And so check it out, robertgovea.com/shop, or just click this shop tab right here. If you want to sign up for the newsletter, click that blue button. If you want to read the show reports, you can do that as well. Just read the show reports here. We put the PDFs on the website. So if you want to grab it, that's the place to do it. And we'll look forward to seeing you at robertgovea.com. And the hats turned out great. I'm pretty happy about them. So, all right, let's see what's going on X before we wrap it up on the day and see who is joining us. We got 8 viewers. All right, it's a little bit lower than yesterday. That's all right. So we got 8 viewers. Danny, Fred, Bessie. We got Jack is here. Jack says, if these cases fall apart, then the Democratic Party loses much of their momentum against Trump. That's basically all they've got right now is what it feels like. We got Anton, Jefferson, George is here. George says, Rob, in order to restore America, all this bitter news must be swallowed like medicine. Says, you're the sugar that helps the medicine go down. Thanks, George, man. Says, great job as usual. Thanks for help keeping us up to date on these crazy cases. Thanks, George. Jefferson says, SCOTUS should hear the case now and make the following ruling. Trump is not immune. However, since any trial will interfere, they're stayed until after the election. They would hate that too. That would be a loss for them. Anton says, what's good for the goose is good for the gander. Should the U.S. Supreme Court rule that a sitting president has no prosecution immunity and double jeopardy, Trump was impeached, does not imply, then Trump's legal team and Republicans should flood Biden and evil Dems with criminal charges. That's right. They could. They could. Would they? We'll see. But they could. Jack says, if these cases fall apart, Democrats lose much of their motivation. Knight of the Desert says, the flip-flopping Clinton sandals need hot sauce. That's a good idea. Jack says, thanks for breaking down these cases. Bessie says, but no one got Joe Biden's burner phone or his records. Maybe James Comer will subpoena the cell phones of the illegally purchased cellular phones that were purchased for Joe. Fred says, I do not like thinking this, but Kavanaugh and Barrett won't vote for Trump. I'm guessing 6-3. So if Barrett and Kavanaugh don't vote for Trump, that's going to, oh, you're guessing, you mean like, so there's 3 lefties. So if you add Kavanaugh and Barrett, that's 5. So that makes it a 5-4 decision against Trump. Fred says, thank you, Gary Shapley and Joseph Ziegler. The corrupt DOJ colluding with the defense would never have been found out. And Danny says, the real question is, where will all the judges go after CNN? After work, will they go to CNN or MSNBC? From Danny. And so, my friends, those are our friends over on the X platform. If you want to follow us on X, you can. And we appreciate you doing that and retweeting the show, retweeting our posts, liking the show, and all the things at Rob Govea ESQ. And it's also cool to join our community called Watching the Watchers, where you can connect with other people on the community. And we've got 1,000 members now, my friends, 1,000 members at Watching the Watchers. And so you can follow each other on the X platform, say hello to each other out there in the wild as we're out there mixing it up. And we'll look forward to seeing you out there. But that, my friends, is it for us on the day. We had this old guy on Locals says, cell phone location data is junk science. 2 phones on different carriers calling from the same location may report locations as much as 20 miles apart in urban areas. That's an interesting one from this old guy. Yeah, I guess it depends on what you're using, right? And who's doing the searching. Like I'm sure the cell phone company could probably triangulate you pretty well based on what it's pinging off the different carriers and stuff. But yeah, it's interesting. I'm sure it's not an exact science, but we'll see what we'll see what Jack Smith says about it. And Rob S. also sending in a dono over on the YouTubes. Thank you, Rob S., for sending that one in. And so, all right, my friends, that is it for us on the day. We are going over to Watching the Watchers. .locals, robertgovea.com for our members only stream. We hope to see you there, or at robertgovea.com to sign up and grab a new hat, purchase a new hat, or purchase some new sandals. The flip-flopping Hillary sandals are there. The t-shirts are there. And we got some other cool stuff that we're working on. So, my friends, that is it for us on the day. And so we are going to come back tomorrow to get into it all again. And we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.